Bill Drummond. I'm a faculty member in City and Regional Planning, and I was able to get this gig only because Bruce Stiftel was out of the country, supposedly in Columbia, not South Carolina, South America. And so I have the privilege of introducing our three speakers tonight. And this is one of our book series in the School of City and Regional Planning. We've had a number of books published in recent years, and one of our celebrations of that is to have a presentation and question and answer time. And so our three speakers and book authors, I will mention, I feel like Jon Stewart here holding up the guest. Zoning and Land Use Law in Georgia by Seth Weisman, Doug Dillard, and Jill Skinner. And I'll give a little bit of background on each of those. First, Seth Weisman grew up in Philadelphia, had an undergraduate degree from the University of Pennsylvania in city planning, and then went to the University of North Carolina, Chapel Hill for a master's degree, and happened to overlap with the Dean of the College of Architecture, Steve French, and the Chair of City and Regional Planning, Bruce Stiftel. So you might have some very interesting stories that would disqualify them for their current positions. And then he attended Duke Law School, where he received his JD. He says his favorite section of the book is the history section, which is at the beginning, and actually I read that over the last week and was very interested in the history section of land and law in Georgia, but also Georgia and federal constitutional law. His hobbies and pastimes, I have heard he actually roots for Auburn in football, despite not having attended there. He does kayaking, gardening, and is an avid and accomplished collector of old Southern pottery, and has apparently played a leading role in an exhibition, actually there's a permanent collection at the Birmingham Museum of Art. So Seth will be our first speaker. Jill Skinner will be our second speaker. Jill grew up in Nashville and then attended University of Georgia for an undergraduate degree in international business and worked for a year for a law firm in Athens and is now enrolled in the Master of City and Regional Planning program at Georgia Tech and the Law JD program at Georgia State University. Her favorite sections of the book, Federal Constitutional Challenges and Georgia Constitutional Law. Apparently, she likes constitutional law. Among her hobbies and pastimes, she's preparing to run the Boston Marathon. She has a green thumb, under development. She ran cross country and track at University of Georgia as a student athlete. And she does not believe that student athletes should be paid, and she does not believe that they should unionize either. So, an interesting take on controversy of the day. Our third speaker is Mr. Doug Dillard, who grew up, at least in part, in Decatur, Georgia, and I understand attended Decatur High, there in Georgia, went to Furman as an undergraduate, and I did not have a chance to get his undergraduate degree, but I understand he played football at Furman. Linebacker, is that correct?
Still paying for it.
And then attended Mercer for law school. I'm not sure about his favorite sections, but they're rumored to be the zoning litigation section and Georgia constitutional law. He also has very interesting hobbies. Dillwood Farms is an organic farm that raises a lot of different things. He gardens, plays golf. I was not able to establish your handicap, which is
It's about 8 or 9, but I can't break 90 right now.
Okay. Well, I guess you and Tiger will be together on the sidelines at
There
the
we go.
Masters.
On the DL.
And for many years, Doug Dillard was referred to as the father of zoning law. And one of his colleagues said, today it's more common to hear him referred to as the grandfather of zoning law in Georgia. So our three speakers will come in order, first Seth, and then Jill, and then Doug, and then we'll open it to questions and comments from the audience. So Seth.
Is this a good place for me to stand? Okay, good. Well, thank you for coming. In class last night, I offered people extra credit for coming to this lecture, and you can see how persuasive I was in encouraging my students to attend. Thank you for those that did. And I was just kidding about the extra credit. You know, Doug Dillard and I have known each other for about 35 years. And when we both started out as lawyers, we found ourselves on complete opposite sides of just about every zoning case that we worked on. And in the very early days of Atlanta, back in the 1970s and early 1980s, I, as a young lawyer in Atlanta, was representing almost exclusively neighborhood associations. And Doug was known as the big bad boy for all of the developers in town, and we frequently tussled over zoning issues and had lots and lots of good fights. And one of the things that I always discovered, and frankly it surprised me because zoning cases can be exceptionally emotional battles where our clients are really at each other's throats, but Doug and I were never at each other's throats. And in fact, I found Doug, and I described him then and I describe him to this day, as just a perfect gentleman who just saw his role as doing a job as opposed to having zoning disputes be anything which was personal. And years later, when I started teaching at Georgia Tech, I invited Doug to start to come and do some lectures on zoning litigation. And even though we had started at such polar opposite extremes in terms of the clients we represented, we quickly found that our values and perceptions and perspectives on Atlanta and its growth had grown together and that we had many, many common views. And one of the things we started to discuss was the need to write a book on zoning law in Georgia. And a lot of people have asked us, well, why write a book on zoning law? And frankly, the answer is very, very simple. And the answer is the law is completely different in Georgia than elsewhere. The procedures are completely different in Georgia than elsewhere. And there are a lot of tricks and traps in the law of zoning and land use in Georgia that if you do not know what those traps and tricks are, you can make a horrible mistake that essentially disqualifies you from proceeding with your zoning case. And Doug will probably discuss this further, but if you're an applicant and you believe that you're being treated in an unfair manner and you wish to appeal your case to court, you cannot appeal as a matter of law unless you raise your constitutional objections before the zoning body that's making the zoning decision. And that basically means you stand up and you say, I'm going to sue you if you do not give me my zoning, and Doug used to be very good at saying that all of the time. But if you don't say it, you're out of luck in terms of being able to bring an appeal. And it's one small example of how if you don't know what the law is, you can quickly find yourself in serious trouble. And our goal, frankly, in writing a book was to give local zoning administrators, lawyers, developers, architects, and planning staff a resource that they could look to in getting answers on zoning questions in Georgia. Now, whenever you write a book and whenever you do a lot of research, a couple of things happens. The first is your spouse inevitably likes or dislikes what you do. My spouse does not refer to this book as Zoning and Land Use Law in Georgia. She refers to it as that damn book, because books always take hundreds of hours more than you ever thought they did. But you end up with lots of interesting tidbits and things that you just never really had a perspective on or knew until you start doing some research on zoning. And you know, I think a few of the things that really stick out in my mind, and I know I've said this to my class, but I never knew that there were 3 things that were prohibited in Georgia as part of the founding of our colony. But there were, and those 3 things were Catholics, and of course Catholics were prohibited in Georgia because of the competition between Spain and England for domination of North America. But in addition to that, lawyers were prohibited, which I thought was very astute on the part of our founding fathers. And also, interestingly, slavery was prohibited in Georgia when the colony was founded, which I also thought was quite interesting. I think one of the other things that really struck me, particularly when I was writing the history section of the book, is you realize how in every period of time, just how quickly things change and how, in many ways, things stay the same. But when you look at our history, over a 300-year period, how land has been used in Georgia has changed tremendously and is still changing tremendously. And as a teacher, it really has always struck me that sometimes I think we plan and focus on too much on the way things are, more so than trying to think about how they are going to be in 10 years or 20 years, often due to circumstances that are completely beyond our control. And in my spare time, I like to think a lot about, well, what's the world going to be like with self-driven automobiles? And does that mean we won't have accidents? And will the automobiles be able to combine together and form little trains, essentially, running on tracks or running on highways? And what would that do to our region if that were suddenly the case? And will we come to a point in time where no one will have a car because a little automated machine will arrive at your door? And what will we do with all of those structured parking lots that take away from urban vibrancy in so many ways? I also think the study of zoning, at least in Georgia, tends to be a bit of a study in how Georgia is not a particularly progressive place to be. You know, when you look at zoning, and the major zoning cases you all know is City of Euclid versus Ambler Realty, and that case was decided in 1926, and it was obviously the landmark decision where zoning was found to be constitutional by the Supreme Court of the United States. Of course, just 6 months earlier, in a case called Smith versus City of Atlanta, our Georgia Supreme Court looked at almost identical facts and were just horrified at the thought that government might regulate in the form of zoning, and struck down the City of Atlanta's zoning ordinance as completely unconstitutional. When I think of things and the birth of zoning, a couple of things really have always struck me. One is how the goal or the purpose of zoning was really to deal with urbanizing cities with noxious industrial uses being introduced into urban areas. And as positive a goal as that was to try to address, what we did went so much further than that, and frankly went so much in the wrong direction. And I'm still struck by Justice Sutherland's comment when he upheld the city of Euclid's zoning ordinance, and he was describing the need to separate land uses. And his focus was not in any way on industrial uses. About the only thing that he really talked about, in his opinion, were apartments, and how apartments were parasites. And it really dawned on me in writing the book that I actually think what Justice Sutherland was mostly concerned about was not the nature of the land use as much as should government have the right to regulate who is going to be your neighbor. And if you thought back to 1925 or 1926 and you thought for a minute about who was living in those apartments, it was by and large an immigrant population that was new to America, and we were in a period of time when there was tremendous anti-immigration sentiment in the United States. And I think a lot of the early zoning ordinances were frankly not so much focused on separation of land uses, but separation of people based on economic class. And as we have developed our zoning ordinances over the last 50 years, you see residential uses, which initially everyone lived together in residential communities, but we started seeing divisions based on size of lots, where the large lots were where the wealthy lived and the quarter-acre lots were where the poor lived. And you start to look at even the city of Atlanta's early zoning ordinances, and the city of Atlanta's zoning ordinance, much to my surprise, had as much to do with enforcing and preserving racial segregation as it was to separate noxious land uses one from the other. And there actually was, in the city of Atlanta's zoning ordinance in the early days, an area that was designated as an area, and I'm not quite sure what word, whether it was African American or black or Negro, but there was an area designated for people who were non-white and non-Christian. And to a large degree, zoning took over a job in separating people that previously had been enforced through private land use restrictions and covenants. In any event, I think I'm digressing and walking or trying to cover too much in just a couple of minutes. We do hope that this book on zoning and land use does become a resource and frankly does help others with an academic interest in zoning and land use issues start to focus more on the nature of our local zoning ordinances and how in particular they can be improved. One of the things about all of our zoning ordinances, and Doug was telling me the story the other day about how the zoning ordinances were very purposefully written to make it almost impossible for neighborhood groups to challenge rezonings. Rezonings were a matter between the property owner and the government, and in the early zoning ordinances now in the 1960s, there was a real move towards making sure that neighborhood groups were effectively disenfranchised. Doug may talk about that a little bit when he gets a chance to speak. But I hope that now that this book has been written, that it will be a resource for folks and that it will help us identify research areas that really need attention and which will allow us to end up with zoning ordinances that are more progressive and really more protective of all of the various stakeholders in the land use process. Jill?
Hi, I'm Jill Skinner Arnold. Thank you for having us. I'm going to go into a little bit more detail and substance of the book. I'm going to talk about some of the differences between federal law and Georgia law, and I'm going to specifically look at takings because I think that that's where the difference between Georgia law and federal law is most dramatic. So the reason that, or one of the reasons that we look really closely now at Georgia law is that in 1985, a case was decided called Williamson County Planning Association versus Hamilton County Bank. And in that case, the U.S. Supreme Court said that to have standing in federal court, applicants or whoever's bringing a zoning challenge has to have first sought relief in state courts if relief exists, and a final decision has to have been reached. And so after 1985, a lot of the zoning cases and land use cases have stayed in state courts because applicants have to go through the state process that's in place before they're allowed to go to federal court. So I'm first going to talk about federal takings law, and then we'll discuss Georgia takings law and compare the two. But I just wanted to start with that to give you an idea of why knowing Georgia takings law is so important, I mean, especially if you intend to practice here. So federal takings law. A lot of people, I feel like, get frustrated with some of the tests that the U.S. Supreme Court has created for evaluating whether or not property has been taken and compensation is due. But we have to remember that the only text that we're working with when it comes to takings is the Fifth Amendment. In the federal context is the Fifth Amendment's, nor shall private property be taken for public use without just compensation. That's all we have to work with. So what is just compensation? What is public use? What does it mean to take property? So it has changed and grown and expanded, and it's now a fairly nuanced area, but I'm going to kind of walk us through it. So it started out where the Fifth Amendment takings provision only applied to federal government officials, didn't apply to states. Once the 14th Amendment was ratified, it was that the takings clause was seen to incorporate through the 14th Amendment to apply to states. So after the 14th Amendment was ratified, the Fifth Amendment takings provision applies to states. So state actors, local officials, it applies to them. Then we get to, what does it mean to take property? If you physically take property, if a government comes in and says, I want to put a road here, I'm going to condemn this property and put a road, that's direct condemnation. Obviously, they're taking that property, they have to pay for it by the terms of the Constitution. What's more difficult is when governments regulate a property so much that you lose certain rights in your property. When a government says, oh, you can't build, a residence over 3 stories, or you can't put a residence on that at all, things like that. So we're kind of in this regulatory area. So in 1922, a case was decided, it's called the Pennsylvania Cole versus Mahone case, where the Supreme Court alluded to the fact that these land use regulations can so restrict property rights that they constitute a taking under the Fifth Amendment. Now, in that case, they didn't hold that there was a taking, but it was alluded to that there could be these things called regulatory takings. Then, as Seth mentioned, the City of Euclid, Ambler Realty versus City of Euclid case, 1926, Supreme Court says, zoning is a valid exercise of the police power. You can regulate property, but we still weren't sure how far the government could regulate property. But zoning's upheld as constitutional in 1926 by the federal Supreme Court. So in the federal context over the next few years, we're still grappling with this question of, what does it mean to overregulate, take property? So we start to get some cases starting in the 1970s, specifically with the Penn Central case that I know many of you in Seth's class have talked about, that created a balancing test. And the balancing test basically looked at what's the character of the government action and how many rights from the property have been taken, or how regulated is that property. So it first created this balancing test, which is typically referred to as the Penn Central balancing test. So we get one test to determine these federal takings issues. Then we get another case that follows that, I believe is in the late 70s, early 80s, called Lucas versus the South Carolina Coastal Council. And in that case, the Supreme Court held that if all rights are taken from property and that it has no economic value, then that is a taking under the Fifth Amendment. So that's our second test. Followed after that is the Loretto versus Manhattan Corporation. And in that case, the Supreme Court held that, if you physically invade property, then that's a taking. So we get these tests over time in the federal context that kind of try to elaborate and expand on what does it mean to take property in the regulatory context. Then we get our Nolan and Dolan, which says that if you condition a permit on the property owner doing something, that condition has to be have an essential nexus to what's being asked, and it has to be roughly proportional to what the applicant is asking for. So we see over time that, in the federal takings context, what it means to take property has changed, it's expanded. It's got these categorical tests, and if you don't fall within those, you might have the Penn Central balancing test. So it's still kind of a gray area, and the court readily admits that it's a very gray area. And it comes down to what are the facts of the case. So that's federal law. You have these 4 or 5 tests that you're looking at. So Georgia law is completely different. So as Seth mentioned, the first zoning law that was the City of Atlanta was struck down as unconstitutional. That was 1926, right before Euclid versus Ambler Realty. After Euclid, Georgia kind of warms up to the idea of zoning as being constitutional, at least facially constitutional. And so we kind of have this period of courts when they're looking at these land use regulations, they're looking at, was the regulation reasonable? And so it's this reasonable test. And then in 1975, we get the Georgia law on takings, and that came from the case of Barrett versus Hamby, which says that you balance the detriment to the landowner and whether there's been a significant detriment to the landowner with the public interest. What's the public interest or the public welfare being served by whatever land use regulation. So the Barrett versus Hamby test in 1975 is still the law in Georgia when it comes to takings. It's this balancing test, the harm to the landowner versus the public interest in the regulation. And you weigh that, and it is a literal weighing test. Unlike in federal law where you have these different categories. So do you have no economically viable use in your property? Has someone invaded your property? Things like that. In Georgia, it's Barrett versus Hamby, significant detriment, what's the public interest or the public welfare being served? And in that case, they talked about constitutional reasonableness and things like that. Didn't expand on it until the year after, 1976. We get the Gould case, and in that case, the Georgia, which was Doug's case, the Georgia Supreme Court created 6 factors that courts would look to determine what is constitutional reasonableness. And these 6 factors were later codified in an act and now are found in most local zoning ordinances. So if you were to go as an applicant now and apply to have your property rezoned, you would have to fill out how you meet all of those factors. So that is pretty much the Georgia law, or in the takings context, and the difference between kind of your federal categorical test and then your Georgia balancing test. And now, Doug, do you want to talk about the zoning litigation?
Well, thank you. You know, as Seth said, we started out on opposite sides of the spectrum in this whole land use connection. And I really appreciated Seth early on. He made me a lot of money because they were always fighting our zonings and folks needed representation, and so we both made money. But as years went on and we were able to develop a body of law, it became apparent that we needed some way to put it together so that it could be a resource for those who were interested in local government and were interested in land use. So when I went to do one of the guest lectures at Seth's class a few years ago, he asked me, he said, "Doug, have you ever thought about writing a book?" I said, "Yeah." I said, "I've had people talk to me about writing a book. But I'm, first of all, no academic. Secondly, I don't think I got the discipline to write a book. And thirdly, I don't know, it takes a lot of time to write a book, but one needs to be done." And Seth said, "Well, I'd like to write a book on zoning and land use law in Georgia and put your name on it." I said, "Have at it, man. You know, as long as I hadn't got to do it, we'll be doing good." So he has, it's Seth's book and it's Jill's book. We brought Jill on to do the research and the actual drafting of it. I had played a very minor role in the drafting and writing of the book, but I think Jill and Seth did a wonderful job, and I hope that if you're interested in pursuing this as a career or otherwise, that you'll get it. I have found it to be useful already, and it's been out, I guess, less than 6 months. I used it a good bit. Let me follow up on this whole litigation thing and the concept of zoning. We don't make money going to court. We make money being able to go to court. And we spend our time working with the neighborhoods, trying to reach an accord, trying to reach an agreement, and over 90% of the cases that we handle are worked out successfully. That does not require litigation. But litigation, being able to go to court in doing what we do is a specialized process. And I think you have to develop an attitude that the Constitution gives us our unfettered right to use our property for any lawful purpose. And that can be interfered with only through a proper exercise of the police power by the local government. As Seth and Jill alluded, for years and years and years, we didn't have, in Georgia anyway, even after the Euclid decision in 1926, the Georgia courts did not recognize local government's right to regulate property. And they denied judicial review of zoning decisions until Barrett versus Hamby. The Tuggle case was sort of a prelim ahead of that, but Barrett versus Hamby came in and said, it is proper for the judiciary to review local legislative acts by local governments to determine whether or not the unfettered right of the property owner has been unjustly interfered with by an abusive, overactive exercise of police power by the local government. And that's a balancing test. And when we had the Gould versus Holcomb Bridge decision after Hamby, the problem with Hamby is it didn't set any standards. We found an Illinois case, got a DeKalb County judge to agree with us, and that became, on appeal, the law of the state. And the 6 criteria that Jill went over are the criteria that you look to, and that local governments must follow in making zoning decisions. Well, how does that form the basis of the litigation? It depends on whether or not the decision by the local government is arbitrary, capricious, abuse of discretion, unlawful, and results in a taking of a valuable property right without first paying fair and adequate and just compensation. Unconstitutional under both the 4th, the 14th, and the 5th Amendments. Now, one of the things that Jill didn't mention is that there is no federal protected property right. The federal cases have said while we look at governmental interference, the taking issue relative to the protection of property rights is a state issue and is governed by the Constitution of each of the respective 50 states. So just keep that in mind. While there are issues relative to constitutional takings that are in the federal side of the ledger, for the most part, litigation involving zoning is a local matter and is litigated in the state courts of the particular states. Now, Euclid, while it opened the doors for local government to regulate zoning, was probably one of the worst decisions we've seen in the arena of land use in the history of our country, because it has shown us over the last 75, 80 years that the separation of uses ain't the answer. The fact that we put apartments here and offices here and commercial here and residential here and segregate those uses, separate those uses, has resulted in what we've commonly come to know as sprawl. And as you go into your life and life's work, all the experts are saying that you're going to demand a different lifestyle. You're not going to demand a single-family home on a large lot. 75% of the country, residential uses, historically, has been large lot subdivisions and single-family detached dwellings. The new millennium, whoever you guys are, is predicted to require a different lifestyle. That the 25% that has historically been a tax cluster, apartments and the like, is now going to become townhomes, is now going to become 75% of that market, and 25% of the market is then going to be single-family detached on large lots. So, as we look at that demographic trend and the demographic changes and the market changes that are getting ready to happen, where are our zoning ordinances? Where our zoning ordinances are basically Euclidean ordinances, period, which deal with facial, arbitrary, and capricious things like distinction between a 10,000 square foot lot and a 12,000 square foot lot and a 15,000 square foot lot. And on those lots, on the 15,000 square foot lot, you got to build a house with at least 2,000 square feet. On a 12,000, you got to build a 1,800 or 1,600 square foot home. And on a 10,000 square foot lot, you build a 1,200 square foot home. Why? You put a 15,000 square foot lot next to a 12,000 square foot lot and drive down the street, and I dare that you can tell the difference, first of all. And secondly, I dare that you can say, oh, that's an 1,800 square foot home and that one's 2,000. And how does that relate to the protection of anything? It's arbitrary. So when we file these cases, we make a facial and as applied a tax on these ordinances, because for the most part, they set arbitrary standards that have no relation to the protection of public health, safety, and welfare, yet at the same time, you're restricting my right to use my property for any lawful purpose, and there's no public protection being afforded as a result of these arbitrary standards. Granted, single-family detached needs to be detached. It needs to be separated by side yard setbacks, so you've got fire protection and utilities will run your water lines and all that kind of stuff. But what is the difference in a 35-foot setback on the front yard versus a 50-foot setback versus a 25-foot setback. Why? I grew up in Decatur on a 65-foot lot, happened to be 300 feet deep. But, you know, we started, our house was a 1,500 square foot house that Dad added on to, and it was probably at the time of his death. He built it in 1948, and he died in 06, only house he ever owned, other than the farmhouse, which is, you know, the source of my little organic farming thing. I'll talk about that in a minute. But it's a lot more interesting than law, I'll tell you that. But the thing about it is that we had a 1,500 square foot home, 2 houses down on a 65-foot lot. There was a 3,000 square foot home. Across the street from that house was a 5,000 square foot home. Down the street was a 1,200 square foot bungalow, all on the same street. They have survived. Why have they survived? Why has Decatur survived like it has? Why has Virginia Highlands come back? Because most of it was developed before we had zoning regulations. And we're now looking back at what we were doing pre-Euclid, and in DeKalb County and Decatur, they didn't even have a zoning ordinance until the 50s. So DeKalb County adopted its first zoning ordinance in 1956. Fulton was in 1954. Gwinnett County today is under a 1985 zoning resolution. They don't fit. They're not going to fit your lifestyle. They don't fit the needs of the public today. And local governments are now being asked to make urban decisions. And the problem they got is they all grew up in suburban. So they got suburban mentalities, and we're asking them to, they're incapable. Forget it. They're incompetent. I told them that this morning, as a matter of fact. They said, you know, Doug, we want you to hold up this zoning you got out in perimeter until we adopt a comprehensive plan. I said, you know, I might not live long enough. You people hadn't got a clue. So anyway, she was a friend, but it's true. So when we look at litigation, I think we got to look at zoning laws that should be designed, and I say this as an organic farmer, should be designed to protect God's created order. Think about that. Rather than setting arbitrary standards that have no relationship to that, create sprawl, which creates problems for the earth, for the air, for the runoff, for transportation, for all the things that we hold dear. So what is it all about? You're going to be the ones that will be responsible for providing the leadership that leads us into real change, substantial change, that hopefully will minimize litigation. Somebody was telling me the other day, what is it? Is it Houston that has no zoning? I said, Dillard, you'd starve to death in Houston. I said, well, you know, you should have been in Atlanta for the last 5 years. You know, it's been pretty bad here too. But look at Houston. Look at the woodlands outside of Houston. They went out there and created a city, mixed use. They've got problems because they don't have land use regulations, but you know, Houston's done pretty good. They ran a 25-mile canal to the water to make, they call themselves a port city. You couldn't do that in Georgia without untold variances and zonings and all the kind of things that you would have to do, unless the state undertook to do it, because they'd be exempt from all the regulations except the environmental regulations. So when we look at litigating, we're talking about the local government's violation of the balancing test that was set forth in Barrett versus Hamby and Gould versus Holcomb Bridge. That's really been reduced to another standard by the Richmond County case. Yeah, Gratis, the Gratis versus Richmond County, which says significant detriment, and it have any relationship to the protection of public health, safety, and welfare? Well, to do significant detriment, you've got to get into the Google tests about what's surrounded, what's near and next door, how long has it been vacant as zoned, does it have a reasonable economic use as currently zoned? And that's always the biggie, is because in Barrett they said, look, all property has value. You don't have to show that it has no value. What you've got to show is that it doesn't have reasonable economic value as currently zoned. And that's a term that they look at, the courts look at on a case-by-case basis. There's no real, quote, standard for what is reasonable economic use. So when we try these cases, we say, all right, we got an agricultural use here. You know, we're going to go through the fact that I could have a church, I could have a farm, I could raise hogs and cattle and all that kind of stuff, but I can also garden. I can also have an institution. I can have an educational institution. There are a lot of different uses. I can have a bowling alley in an AG district. So we got to go through and say, okay, these uses don't fit this zoning classification. And it's not about what we ask for, because the courts will take judicial notice that what you ask for is going to create value. It's going to be more valuable after you zone it than it is before you zone it. So the courts don't let you get into it. It's not what you ask for. It's whether or not the current zoning as imposed on this property has reasonable economic value, and as such, not having any reasonable economic value constitutes a taking of the valuable property right without payment. So when you try these cases, you need appraisers, land use analysis, you need land planners, developers, and of course the property owner. Now, what can the courts do? All the court can do is to find that the property is unconstitutionally zoned. The courts do not have the power to zone. The Constitution gives that exclusively to the local government, cities and counties. So all the court can do is declare the zoning unconstitutional, and we also go into other uses that would be unacceptable to us, so that when the court rules, they rule on the intervening classifications that exist between what we want and what we got. Send it back. The court retains jurisdiction, most of the time for 90 days to 6 months, directs that the Board of Commissioners or the City Council zone the property to a constitutional classification. And if we've done our job, we have proven pretty much the classifications that we don't want are not proper, so that the discretion of the local government is limited to where they consider the commercial zoning or the PUD or the various apartment zoning, whatever that might be. So that when they zone it, the court has given them direction on what they should consider in finding classifications, intervening classifications as unconstitutional. So let's say we're asking for commercial and we're zoned to a single family. We want to go through the multifamily. We want to go through all the single family classifications. We might go through an office classification to get to the district that we want. And that is pretty much the process. The appellate process is a discretionary process. If I don't like what they did, I can appeal. It's a discretionary appeal by the Supreme Court. Less than 15% of those appeals are granted. So it's pretty hard to get an appeal. So as far as litigation goes, the real fight is in the lower court. That's where you really got to do your work. But I think the thing, if I want you to take away anything here today, is that the myriad of zoning classifications that we've got in these zoning ordinances are 50% unnecessary. Like I said, you know, why are you going to worry about 5, 10, 15, 20,000 square foot lots next to one another? The key is mixture. The creation of balance means that you've got a variety of opportunities within close proximity to one another. And that includes both residential and non-residential uses. And if you look at the areas that have come back and the areas that were developed before we had zoning, like Virginia Highlands, Decatur, and the examples that I made, those areas that are coming back that have got that mix in close proximity to pedestrian activity, to limitation on automobile use, to sense of community, to accessibility, to pedestrian activity, those are the areas that are growing today. And so we've got to get these ordinances changed, and they've got to be reflective of the future demographic trends of our country. And the most important, because Seth was so right, land use laws initially were used to keep people out. Land use laws in the future need to be a vehicle to bring people together, and in so doing, protect God's created order. Thanks.
I think we might have time for a couple questions, but I thought I might start, given what Doug Dillard said at the end. I wanted to give an opportunity to both Jill and Seth to ask. You can answer either of these varieties of the question, but you can take it as a negative. What in Georgia land use or zoning law would you be most eager to fix if you became king or queen? So what would you be most eager to fix? Or on the positive side, if you were enabled to do any one major innovation that might make Georgia a national leader in an area, what would that innovation be? So either your biggest fix or your biggest innovation. Joe, you want to go first?
Well, my biggest, I don't know if it's a fix or a clarification, it probably is more of a clarification, would be to better explain the function of overlay districts. So right now we're seeing a lot of overlay districts pop up in different jurisdictions. The problem is that when these overlay zoning districts are put on top of an underlying district, sometimes it gets confusing either which regulations trump and take effect, and also there's conflict with the overlay and the underlying zoning districts in a lot of these cases. So overlays are supposed to add certain design features and characteristics or add certain uses, but it's not supposed to conflict with the underlying zoning. So if you have an underlying residential zoning classification and you put an overlay on top of it that allows for industrial uses or high density commercial uses, there's a conflict there. And I think that what we're seeing is local governments doing that. Instead of using overlays as they were intended to be used, you have your underlying zoning district and your overlay is supposed to add certain architectural standards. So if you want the facades of buildings to look one way, or if you want to revitalize an urban corridor or something like that, it's these design features, wider sidewalks, things like that, rather than changing the underlying use and the underlying zoning. So that's, I don't know if it's a fix or more of a clarification, as I said, but.
Do you have any guess at the number of different overlays that we?
There are, in the metro Atlanta area, I would say a majority of the jurisdictions have overlays. And some of them, I think it's Roswell, has multiple overlays. So you could potentially be living on a piece of property that's zoned residential. You have a historic overlay. You have, I forget what their other one is, like a downtown urban core overlay and then something. So you could have multiple overlays. But almost all jurisdictions in the metro Atlanta area have overlays or will probably soon have overlays. The trend.
If I were just adding a couple thoughts to what Jill has said, I think my greatest concern as a lawyer and a teacher is I happen to think our governmental regulations should be capable of being understood by the average citizen. And I happen to think our biggest problem is that, you know, there are a lot of good things happening in terms of zoning regulations. A lot of the overlays are trying to achieve very positive, you know, they're written for positive purposes. You know, we're starting to see some form-based zoning in Georgia, at least in city of Roswell, and I think that's certainly a step in the right direction. But unfortunately, in trying to make things better, I think we are making them more complicated and harder for the average citizen to understand. And that, to me, is not something that anyone seems to be addressing. And I happen to think that you shouldn't need a lawyer to interpret the law for an average citizen. Now, the other thing I feel very, very passionate about is our zoning laws are written to prevent neighborhood groups from having access to the courts. You have to follow these very arcane procedures that the smartest lawyers in the state are often scratching their heads trying to figure out how they can actually have standing to go to court and assert a claim. And, you know, we were involved in a case about a year ago that's now up on appeal, but it was a case where the neighborhood went to a hearing to learn more about what the developer was trying to do. And a decision was then made to approve the developer's request. And this was actually not at a county commission level, it was at a planning commission acting on a plat review. And basically on appeal, the DeKalb County government and the developer both said, well, you know, yes, you were at the hearing, but you didn't present all of the evidence that you could have presented, and anything that you didn't present at the hearing is not a part of the record and now can't be raised. And you know, the neighborhood is quite legitimately saying, well, how did we know to raise it? And we were hearing about this case for the first time. We were there to learn. And now you're saying on appeal we have no rights. And frankly, that's not an uncommon type of situation in Georgia. And, you know, Doug can explain some of the, because at least it was his daddy who did some of these evil deeds. But I happen to think that we should not be barring the door to the average citizen to be able to address land use issues. And I think we've effectively done that in Georgia.
Yeah, that's the whole difference between quasi-judicial and legislative functions. Zoning's legislative, appeals, permits, quasi-judicial, and that, what Seth's talking about is a whole nother lecture. If I had a chance to do something following up on what I thought, I'd eliminate probably 2/3 of the zoning classifications. Because they're exclusionary. And by creating let's say you created an area that could have single family or multifamily up to a certain number of units, I think the limitation on density needs to be directly responsible to the availability of infrastructure and how we can provide water, sewer, fire protection, that kind of thing, because that is a proper exercise of police power. Outside of that, they shouldn't give me an arbitrary limit of 8 units when the market's calling for 16. So I've got a situation right now that I talked to the city of Brookhaven about. We're asking for detached cluster zoning. To do that, we've asked for an RA8 classification, which is a multifamily, condo, apartments, or detached deal. And the 8 stands for the 8 units per acre. the requirements of the ordinance for a detached product is a 60-foot lot and a 6,000 square foot minimum. Well, 6 times 8 is 48,000. Last time I checked, the acres less than that. There's no way I can put 8 units in a detached product. As a matter of fact, with the 60-foot lot, with the front and side yard setbacks that I got, my density is 4.3 units the acre. So why? It doesn't relate, and this is the development that's on 2 major roads. So
Yeah, and really
I think
what,
you don't have to have all this.
right, what you're really saying is that the ordinances are still stuck in the 1960s and really are not we need to figure out how to become denser as a city, and our ordinances aren't letting us get there. And unfortunately, there's not political will necessarily in support of increased density and different development patterns. You know, Doug's had a number of cases in Dunwoody recently where, you know, the city councilmen stand up and say, we like Dunwoody just the sleepy way it's always been. You know, now Dunwoody is no longer a sleepy suburban locale. It's an edge city next to the largest employment center in our state. And yes, Dunwoody needs to get denser at the right locations.
Okay, we can take questions here, and I'll probably try and repeat the question for the purposes of the microphone and maybe simplify it a little bit. Questions from our audience? Barbara Fagan.
The City of Atlanta is considering a new zoning ordinance. They've talked about a number of different aspects, and they're looking at form-based code. Could you talk about that a little bit?
And the question is, City of Atlanta's new ordinance discussing form-based codes. Maybe you could give a quick positive or negative and reasons for that.
I'll let Doug talk, and then if I disagree with him, we'll argue.
Mm-hmm.
Perhaps you could explain basically what a form-based code.
Let me just tell you this, that the City of Atlanta ordinance needs to be done. It's a 1983 ordinance, so it needs to be shelved and blown up. I think there's an opportunity to have a combination with form-based. Form-based code is not the answer because it's form over substance. I think you've got to have a blend of our traditional regulatory deals and then let the form-based code talk about how we make it compatible and how it's not unlike an overlay where you use those forms in order to fit it into the neighborhood. But we got a fight going on right now in East Atlanta over a Walmart, and we've got the belt line in court, and we got neighbors all fussing at each other. We finally got it worked out, but it was a Donnybrook there for a long time, and it was really more of an argument over form versus substance, where we were working really hard to adapt to the belt line criteria, yet at the same time we had a retail use that was permitted by the underlying zoning. The Beltline overlay called for another use on that property. They treated it as a zoning ordinance when in fact it was not. The overlay talks about the form in which we develop and how we do our streets and our lighting and streets, all that kind of stuff. It does not control the underlying zoning use of the property. And so that's where this needs to be a real clear understanding. If you're going to put form-based codes in play, you got to be sure that you create that balance.
You know, if I were just adding anything, I like form-based codes. I think they're better than a lot of the things that we have. My fear as a city planner, I worry mightily that every zoning ordinance is arbitrary at some level. Every zoning ordinance has unintended consequences that years later we may look back at and say, boy, that, are we going to eventually in 50 years be looking back at form-based codes the way we're now looking at Euclidean zoning and saying, what were they thinking in 2013? And I worry that as city planners, we sometimes gravitate towards one-size-fits-all solutions that are trendy and popular until they are no longer trendy and popular. So while I support form-based codes, I do worry will that result in a homogenization of a development pattern and eliminate originality and creativity that I think could add to urban vibrancy.
Yeah, well, I would just second what Seth and Doug have said. I would go for what Doug was saying with kind of a hybrid form-based code where you do away with some of the underlying, R100, R75, those small differences that Doug was talking about when it's just, 1,000 square feet difference between these different zoning districts. So I would keep underlying use regulation, but maybe broaden the underlying use as, residential, commercial, industrial, office. And then the form-based, architectural standards, sidewalks, lighting, those things. I think they should be encouraged. I think form-based codes are good, but I think they should be hybrid form-based codes, so that some use regulation is still included in those.
And if you've not been to Doug Dillard's organic farm, you should go because it's really like the coolest thing in the world. And you should ask to participate in his, what is it called?
CSA.
CSA, because he raises the best tomatoes I've ever eaten.
Well, we sell to about 20 restaurants here in Atlanta. Optimist, all Ford Fry stuff. Kevin Rathman and Eugene and Aria and Haven and Valencia. Got about 20 restaurants that we sell to. So.
And where is it?
It's in South Gwinnett County between Snell and Loganville. It's been the family since the late 50s. We've got 60 acres out there. We're farming about 10 or 11, trying to figure out how to create a sustainable situation on a smaller piece of property before I started doing it all. So, we're about there. This is our 5th year. We're not certified organic. We're certified naturally grown, but we are organic, and we'll probably be certified this year. But it's all of our food is chemical free. It's about healthy eating. It's about childhood obesity, childhood diabetes, trying to teach our young people as well as old folks like me who want to stick around here a little longer that you are what you eat. And so. I
think I see another book coming. Thank you. Let's give a hand to our presenters.